Hi, Sarah Andrews.
Good morning.
Meredith. Justice Donnelly. I see you're busy writing concurrences today, or dissents. Justice Donnelly.
Good morning, Your Honor. How are you?
Good morning.
Hey, Michael.
Yeah. I'm on a roll. Yes. Can you hear me okay?
Michael. Good. Who said
Good
that?
morning.
There's Justice Donnelly. I think it is running slow. Michael, can you hear me?
Yeah, Judge, are you having issues on your end? Because it's running, I can't see anyone
You were
here
frozen for just a
except for
bit.
you, but it's very jumpy.
Michael Woods.
Judge, you want me to try
I can hear you,
Closing
Justice
the-
Donnelly, but you're the only one that isn't frozen on my screen. So I'm trying to reach out to Michael Woods, who's our tech support person, excuse me.
Gene, I hate to tell this
We've had a nice attendance today,
tell you,
which
but
is
your
great.
screen is
Yes.
frozen.
Can you hear me
I
okay?
don't see anybody other than you.
Unfortunately, it's frozen on the
Yeah,
wrong
you
side
froze
of
up
your
for
face.
just a moment or two.
And Judge, can you hear me? You're the only one I could hear and see.
It is very jumpy. The only person I actually see is Justice Donnelly. I have a frozen image of
Should we
Catherine
leave and
and a frozen
readmit?
image of Sarah Andrews. Everyone else is named, dark screen, muted. And reopening, is that what you're suggesting? Oh, there's Doug DeMoult, maybe. Doug, can you hear me? So Michael Woods, if you would please, let's, I think whatever you need to do to maybe reboot or something.
That's exactly what I see.
All right.
Yes, I can, sir.
Judge Bergeron, he's frozen too. Mark Godsey just texted. He says he's having issues too. I think it's not working for all of us.
Judge,
Yep. Michael, this is Judge Z. Why don't we Why don't
Think we
because
should
of spotty connection.
Send out a new link.
Sorry, it's very delayed on my end. I just put in the chat though in that I'm gonna shut down the meeting and open it up for everyone to rejoin at 10:10.
Okay, great.
Nice to see you too. So is Pierce on there?
He was, oh yeah, well, he's still booting up, and unfortunately, we're still connected to Champaign County, so.
So I just wanted to tell him that we passed the recording of interrogations yesterday in the House. So I know that he was extensively involved in that. And so I just wanted to let him know that we passed that yesterday, and hopefully we'll get the Senate to do the same thing this time.
And I think you passed it last session, did you not?
We did,
Yeah.
but for some reason it didn't make it out in the final. So we're hoping that we did it a little earlier this time. In fact, we suspended the rules to get it passed. I mean, it wasn't supposed to be on the floor yesterday, but we suspended the rules to get it on the floor a little faster. So now we've passed it, and hopefully we'll get it passed to the Senate this time.
Okay, great. So let's see, I know we had Judge McIntosh had connected earlier. Judge Bergeron, good morning. Meredith O'Brien, good morning.
Morning.
Good morning, Your Honor.
And Watson, Mr. Martin, we have arrived. John,
Good morning, Your Honor.
it was a nice little chat line, loved it. Thank you.
So when do the Mud Hens start?
They started home May, but I think their season starts in Indianapolis in a couple of weeks,
No.
next week. So, because I think the first month they're all regional play before they go to their respective home.
Well, they're probably doing inter-squad play right now, sort of the exhibition.
Yeah.
Yeah.
Yeah. So anyway, I went to my first baseball game a week ago Monday
Where?
up in Detroit.
Oh my gosh.
Yeah, I got to go see a Tiger game.
Were you in a pod?
They have seats that are separated, and however many is in your group, you would 2, 4, 6, you would sit there, and then all the seats around are cordoned off. So they know what percentage of the stadium presently they can actually sell tickets for, and then as that increases in terms of capacity, they'll open up more sections. So everything they've eliminated cash though. You can't buy a beer or bag of chips by cash. Everything is card, which is another way.
It's kind of nice to go to a game with only 3,000 or 4,000 people there, isn't it?
Yeah, we remind me actually going to a Mud Hen game, quite frankly. So
yeah,
it's 50 some. It's cavernous. If you ever been up in Detroit, but it was nice to be back in Cathedral of Green, as I call them,
right.
Stadium. So. All right, sorry. Good morning, everyone. I think there's Judge McIntosh. Okay, I was waiting for my leader to come online before we get started. So I think, Catherine, there you are. I know Senator Gavarone expressed that she can't make it. Judge Navarre indicated she was going to be late. And I just got a text/email from Tim Young, who's running late. And hopefully we'll be able to join us later this morning. Other than that, is there anyone else that you're waiting on? Catherine or Brian?
No, Judge.
Let's get started then. So good morning, everyone. We're a little bit delayed because of technical difficulties, but we're up and running now. This is the April 16th meeting of the Task Force on Conviction Integrity Post-Conviction Review. A lot of material that hopefully we can complete getting through, and heading toward the end of this great experience in this task force work. So the first item on the agenda, of course, is the approval of the March 19th minutes. Each of you should have received copies of those minutes. And I'm looking to see whether or not there are any corrections, deletions, additions to those minutes by anyone? Seeing none, could I have someone indicate by hand a motion to approve? Justice Donnelly, motion to approve. Meredith, can I use your hand as a second? Excellent. All in favor signify by the hand. And thank you. Any opposed? Same sign. Minutes have been approved. Thank you all. We started last month identifying news-related stories relative to wrongful convictions as a consequence to a number of different stories that I have become aware of. The only thing that I wanted to make sure is that everyone has now actually seen the State versus Sutton decision. Joanna, are you here? I thought I saw your name. Oh, there you are. Yes. That is now public, and each of you hopefully have had an opportunity to review that. Are there developments in that case, Joanna, that you want to talk about real quick?
Sure. The state.
Oh, that's appropriate. I'm not asking you because it is back in the trial court, right?
Well, the state filed a motion for reconsideration in the Court of Appeals, and that was denied earlier this week.
Okay.
And the proceedings are currently stayed in the trial court, I think, while we see if the state's going to appeal to the Supreme Court. Since Justice Donnelly's here, I won't say any more.
Yes, that's right. So all right. Thank you very much. Anyone else have any news stories? We didn't get any from any of you. I just want to make sure we didn't miss that opportunity. Seeing none, let's move on then to the meat and why we're assembling here today, and hopefully accomplish final discussions and voting on proposed changes to Criminal Rule 33 and 33.1. We had a vibrant discussion last month, which talked about trying to create some parameters and understanding how do we distinguish between wrongful conviction petitions versus standard post-conviction petitions, or which are oftentimes filed under motion for new trial under 33. We have sent to you which was at the time the latest version of the new trial rule 33 and 33.1. I think we need to discuss these in tandem because they are related to one another. And as I understand it, there has been some work by some task force members trying to work out some agreed upon language or language that would modify that which is before us. Who wants to take the lead relative to this? Justice Donnelly, I know you kind of framed the standard.
Sure, I'll just say, I think what we've formulated, even though it's not finalized, there's been a couple of tweaks even in the last 2 hours to the language that I think improves the rule, but I'm really proud of this rule that we produced on this task force, and I want to thank everybody on the task force that worked on it between last meeting and this meeting. I also acknowledge Rachel Troutman from the Ohio Public Defender's Office, who played a significant role in helping raise concerns about some of the initial language and helping us formulate it to where it is now. But I think what we've done is what we talked about at the last meeting. We've now created a mechanism which provides claims of actual innocence with their own path, free of all the procedural wranglings that litigants have been dealing with and time constraints, which will promote the use of open hearings and allow litigants to get to the merits or the lack of merits of these claims and provide a detailed record which will give appellate courts the ability to provide meaningful review on the process. Now with their own path, actual innocence claims can now be more easily tracked within the system and identified. And this will allow our courts to place time constraints requiring more timely rulings, more detailed reasoning in those rulings, again, greater transparency, and less unnecessary delay that exists in the system now. So I think this is a major step in the right direction. And I look forward to the discussion about concerns or revisions, but I think it's really shaping up to be something that's going to advance post-conviction significantly.
So I said we were going to consider them in tandem, but maybe what we should do is let's just confirm that 33.1, which is the new rule that's being generated that pertains specifically to exoneration claims or wrongful conviction claims of innocence. Let's do this. Brian, if you want to pull up the screen, I assume everyone has had a chance to review that language. I think there may be some suggested modifications of that language, but let's deal with the language before us. Okay? So Brian, can you do that?
Do you want me to pull up Justice Donnelly's version or the,
Yeah.
Okay.
And as he's doing that, just to frame this, we started this effort with trying to modify 33. And I think after lengthy discussion, it became clear, and I believe it was Judge Savage who said, maybe we'd be better served if we just carve out a separate rule that pertains to the post-conviction or new trial petition for those that are claiming actual innocence, exoneration, which is really why we created the 33.1 rule that you're now looking at. After further discussion, such that, and trying to address the concern that the rule should be narrowly crafted so that it only pertains to those claims that are seeking actual innocence. Here's the language that we forwarded to everyone. Justice Donnelly, are there some additional suggestions or modifications beyond this that
I'm sorry, could I ask Brian to increase the size of the screen so I can read this?
Oh,
Is
sure.
that possible?
Brian, can you do that, please?
Yes.
Have you forwarded this around to everyone? Because this is the first time I'm seeing a lot of this language here. I had Justice Donnelly's edits from yesterday. I think that were forwarded by Brian to everyone, but was this on the shared drive for some modifications?
It was, well, Brian, this is what we got from Justice Donnelly when? Yesterday?
This was a week or so ago. But
yeah, a week or so ago.
We made some changes since then that I think improve this. Basically, in section A, we replaced clear and convincing with relevant and admissible evidence, because I think our trial court judges are very well equipped to recognize that any alleged new evidence, how significantly it undermines the theory of guilt that was used to convict the defendant in the original trial, and therefore can make an assessment at a hearing on whether the evidence would reasonably produce a likelihood of a different outcome at trial. So I don't think I heard back from Mark Gotzi and Joanna and their concerns about having these kind of a dual standards in there and misinterpretation that might be employed by judges to have that. So I think the suggestion of replacing clear and convincing evidence with relevant and admissible evidence, and keeping the standard that a reasonable likelihood of a different outcome of trial is something that our trial court judges and the litigants can argue for or against at a hearing, and it's much more straightforward. So that's the revisions that took place. We wanted to keep the language about undermining rather than a misinterpretation where judges would think that there would be some type of burden to actually prove innocence. What we're talking about is providing the court with new evidence that wasn't used at the time of the original trial that undermines the theory of guilt that was used to convict the defendant in some significant way or directly contradicts evidence that was used and was embraced by the jury when they made their assessment whether the charges were proven beyond a reasonable doubt. And that's why you'll see no language about actually having to prove innocence, as we discussed pretty extensively at the last meeting. We're talking about evidence that, go ahead.
No, I'm sorry. I just wanted to put in there the modification that you're seeking is to take out clear and convincing language in paragraph A and put in what's the
relevant and admissible evidence.
okay.
Therefore, like a petition that would have an affidavit that would be clearly hearsay would not meet that standard. It would have to be relevant and admissible.
Okay.
And we provided this rule, what it does is provide guidance to trial court judges in assessing when a hearing should take place, rather than summarily dismissing petitions based on what is alleged in the original petition and the brief in opposition. There's clearly a threshold obligation on the petitioner where judges can dismiss motions that are patently frivolous, and we thought it was important to define what is patently frivolous, and that is motions that do not offer any new evidence that could be tested as to its credibility or to the degree which it undermines the guilt of the theory of guilt used to convict, and that we hope will promote and guidance to the trial court judge when to hold a hearing and when not to. And we have, once you meet that threshold, discovery can take place, and we identify in Section E the types of evidence that can be included but not limited to, at these proposed hearings. And then there's an opportunity to, if the reasons, if there are reasons why perhaps the trial court who tried the original case should not, because of rulings made or credibility assessments made at the earlier hearing, might not be the appropriate judge to hear this new trial claim. So that's what Section F is. So that pretty much summarizes my understanding. If
So at
anybody
this
wants
point,
to
then what
add,
you're asking is to substitute relevant and admissible evidence for clear and convincing evidence.
yes.
Brian, can you put that in there, please?
Now, Judge Bergeron has drafted or reconstructed this same rule that incorporates all this, but then reincorporates some of the procedural aspects that were in the original draft that I think the trial court judges will find as an improvement. I don't know if you have that ability to show that latest draft.
Judge Bergeron, can you send that to, I don't think you sent that to Brian, did you?
No, I flipped it to you early this morning.
Okay.
I can send it to Brian right
Send it
now.
to Brian right now, if you would, please.
All right.
Because what you actually do is you put in a procedural section between time
Right.
and evidentiary hearing. Then Brian, let me know when you get that.
Well,
Justice Donnelly, have you reviewed Judge Bergeron's formatted rule?
Yes, and I believe it's an improvement from my.
So in other words, rather than look at this, you're suggesting we could review that
Yes.
proposal. Okay, it incorporates everything that you've attempted to put in here, plus then the procedural steps that Judge Bergeron has reinserted based on what we had initially talked about.
Right.
Okay. And while we're waiting for that to happen, I just want to make sure that I've received no other proposals from any other task force members of potential changes to either 33 or 33.1. And if any of you have, I just want to be clear that I've not seen that. And I just want to make sure none of you have sent any additional potential language changes. Silence means yes.
There's a couple of hands being raised.
Judge Savaggio, you raised your hand, but
And
that
Doug-
wasn't in conjunction.
Doug was first, so
All right.
I yield to Doug.
But that's not in response. Both of your hands were raised prior to my question just now.
Yes, sir.
Yeah, okay, all right. Doug, you want to, while we're waiting for this to come up, you want to talk? You have a question?
Sure. It's not really his question. I appreciate the work of the folks from OPD and the rest who put some time and effort into the kind of drafting that 33.1. I guess one of the things that I'm not understanding through there is this seems to be a kind of a fairly broadly construed mechanism, not tied to actual innocence, but towards undermining guilt. And I went back and I watched the presentation because I wasn't here at the last meeting where they had the discussion of the purposes and kind of what the goals of the next follow-up meeting would be. So I kind of understand some of what transpired last time. I did just want to flag it as a concern. I said, I just don't think that you're going to get broad support from many of the stakeholders with how the 33.1 is currently viewed. I think you'll get a lot of buy-in from defense counsel as well as some in the judiciary. But frankly, I'd probably expect our office as well as most other law enforcement related kind of stakeholders to come out very strongly against a proposal that incorporates almost any of what's in the 33.1 as it's now envisioned here. I think it's well crafted for its objectives and goals, but it's very different than some of the ones we originally talked about as part of the kind of the purpose of this. And it doesn't necessarily track the objectives of trying to provide a safety valve for folks who are actually innocent of crimes. This seems to be depending on how you count it, 4th, 5th, or 6th bite at the apple to litigate a bunch of procedural claims and other types of things in addition to potentially actual innocence. And so I'm happy to go through and talk as we go through specific concerns, but I just wanted to be very transparent that if something comes out very similar to this, I just don't see much of a chance of getting support like from our office and other folks on who are more aligned sometimes with the law enforcement community than others.
I appreciate, Doug, those concerns, and they were definitely in our mind as we were drafting this. And at the last meeting where Carol was here, I sided with her in the fact that, you know, there was this discussion on there's a spectrum of innocence claims, you can't really define it, and I sided with her in the assessment that no, actual innocence means you didn't do it, you didn't do the crime. So we understand lawyers' concerns who litigate on behalf of people claiming that they're innocent, because not every claim of innocence is going to have merit. There's going to be guilty people who claim that they're innocent, and I think through this mechanism, through shining transparency and encouraging hearings, those claims are going to fall by the wayside, and so I welcome that debate, because I think the assertion or the claim of actual innocence should belong to the prisoner, not the Innocence Project, not ODP. It's the person, and that's what this objective of this task force is to deal with claims where the prisoner are claiming that they are actually innocent. And so it's not this nebulous, like second bite at the apple and it's a valid concern. I would be articulating it if I was in your position as well. But I think when we see these procedural reincorporations by Judge Bergerons, I think it might satisfy, but I look forward to the discussion.
So, Mr. DeMalt, if I understand your point, you're just saying it sounds to me that what you're really doing is you're making general accusations that this really isn't what we had talked before and therefore won't gain support without providing any specific directions as to how to modify it so that it's consistent with the position that we have agreed to as a task force.
No, I don't like the word accusation, Your Honor. I would resist accusation on there just for how you characterize it. And I'm happy, like I said, to walk through and provide specific feedback on various points. But
that is the point of this task force meeting, Mr. DeMalt. Okay.
No, I appreciate that. When I saw the version come through here and I saw the agenda, it was a little concerning in terms of the where we are in the process. And obviously, we're looking to look at some additional language here in a few minutes. But yeah, I was a little concerned when I took a look at this and see that. I mean, if you look at it, even frankly, the standards that we're talking about are far below even like manifest weight of the evidence standards. So, the reasonable likelihood of producing a different outcome at trial, those kind of things, there's a lot of details we could walk through, and like I said, I'm happy to do it. But I didn't see anything in the current version or the most recent version that was emailed yesterday that kind of focuses on people who are actually innocent versus on folks who might have some that undermines the theory of guilt, let's say.
Okay. Anyone else? Nick, Judge Salvaggio, excuse me, sorry.
No problem. So I have essentially 2 points and then a request for clarification. Picking up where Doug left off, I think my general concern about the word undermine is that it conveys a feeling that we are re-examining reasonable doubt. And when I initially saw this version, I had thought that the rule, I mean, what we're trying to address are those instances of actual innocence. And I think Justice Donnelly's concern and Tim Young's prior concern that we don't require the defendant to prove their innocence, but what we're really talking about here is the concept of actual innocence. And I think at some point or in some fashion in this rule, we need to say what we mean, because the practitioner and the trial judge is going to lose the spirit of what we're trying to do. And the spirit of what we're trying to do in this particular rule is to address those instances where, hey, somebody's actually innocent here. Somebody's been wrongfully convicted. Somebody has, doesn't belong into this category of conviction. And so I had actually written as the title of the rule, new trial based on evidence demonstrating actual innocence of the defendant. Because I think that needs to be clearly stated somewhere. And when I see the word undermine, we start to get into that area where we all recognize that there's this concept of reasonable doubt, and anything can undermine reasonable doubt. And so I think we start to wade into some waters that we don't intend, and that others who want to use this rule are not going to understand. So that's point one. Point two, I've got a real concern about subparagraph F. Effectively, subparagraph F will exclude most of the rural judges that are single judge courts. And I'm sure that was discussed at some point, or two judge courts, where you have a situation of an administrative judge. As an aside, if subdivision F is being created because there's a perceived conflict, then the Supreme Court is going to be the one making the appointment. It won't be the administrative judge as a practical matter. And secondarily, we then also start to get into this area of the law where you have a trial judge who hears a motion to suppress, has really adjudged the credibility of those witnesses, yet is still able to preside over the trial. And so I think subdivision F opens up a can of worms that really has longer consequences. And I'm also wondering, you know, are we really setting a different standard for people that live in rural communities than we do the people who live in larger jurisdictions that have more judges? And then lastly, with regard to subdivision C, I very much appreciate that patently frivolous was defined or sought to be defined. What I didn't know and what I was looking for clarification is in the last sentence where it says, the court shall promptly issue a decision articulating the court's reason that supports the court decision. Are we talking about the court decision to declare it patently frivolous, or are we talking about the court decision on the hearing on the motion for new trial? So those are my 3 points.
Okay. Steve, I see your hand is up, but before we listen to Judge McIntosh, do we want to get a response to those specific questions raised by Judge Salvaggio? Justice Donnelly or Mike Gotts?
I think those are valid concerns that are just, I mean, I started out my statement, this is to provide a path for actual innocence. And I don't think we should hide it. I think we should kind of identify that. But, you know, in our discussions, why we thought undermine was so important, you know, we talked about specific examples. For instance, the Angela Garcia case in Cuyahoga County. This was a woman who has maintained her innocence from day one, and she was convicted of setting fire to her house, and her 2 children were unfortunately killed in this incident. And in her original trial, she had the state had a forensic fire expert testify, which was a significant piece of evidence that formed the basis of the state's theory on how she intentionally set that fire. And she was, after 2 hung juries on the 3rd trial, she was eventually convicted. So flash forward 16 years later, her lawyers have contacted an expert who is aware of all the advances in science and reviews the testimony that was given at trial by the state, and is able to opine that none of the testimony was by today's standards scientifically reliable. And what we discussed yesterday is, look, if that doesn't prove that she didn't do what the state alleges what she did. The state wasn't there, defense counsel wasn't there, I wasn't there, the trial court judge wasn't there, so no one's going to know that. But you could look at that objectively and at a hearing, and if you find that new expert is credible after cross-examination, then you've taken out a significant piece of the puzzle that was used to convict her. So it's not like second guessing reasonable doubt. It's just identifying information that trier of fact did not have and should have. So it's more of trying to take the credibility findings out of the trial court judge and just say, you know, was a significant part of the building blocks that form the state's case is that now gone because the evidence has been totally discredited. And so, but I have no objection of trying to identify, and like Judge Salvaggio said, that this is a rule for the prisoners who are claiming actual innocence and no one else. And
Gene,
Yes.
If I could just comment on a couple points. One, my revision on this was designed to kind of clarify the procedure a little bit. And in subsection D, I addressed Judge Salvaggio's last point because I agreed there was ambiguity there. But I think the other issue that we've all been kind of circling around is how do we define actual innocence? And I think that the concern from the defense side is that I think was expressed last time was, it's very difficult to prove actual innocence. Like you can completely undermine the theory of guilt, as in this rule, but someone could still reasonably say, I'm not convinced that guy's actually innocent. I'm convinced he deserves a new trial because all the evidence has fallen apart based on the newly discovered evidence, but that doesn't necessarily mean he's actually innocent. And so I think that the difficulty is coming up with something that doesn't set an impossible barrier to establish, entitlement to relief, because if we have a rule that's impossible to satisfy, no one will avail themselves of it, and it'll just be a hollow letter. I think that's where kind of the discussions about undermine the theory of guilt kind of morphed. And I think someone had mentioned that on one of the prior conversations. The other thing that I just wanted to draw attention to was the reasonable likelihood of a different outcome at trial is kind of borrowed from different areas of the law, like Brady and Strickland, and frankly, some of our sister states who have that standard for new trials. So it's not as if that was, cut from whole cloth, but more like an appropriation of other standards. So I freely recognize the challenge here in striking the right balance, and maybe this draft doesn't do it, but I think that that's the real crux of the issue is how do we provide a rule that cuts through the procedural morass that is there right now, which this does, but then obviously doesn't open it up to every single person that just throws together a motion, and that's why we tried to incorporate some safeguards in there, but certainly open to input on how to further refine it.
All right, thank you. So, well, Judge McIntosh, you had your hand up next, so we'll go to you, and then I know, John, you had yours up. We'll get to you next. All right, thank you. Steve?
Yeah, thank you, Gene. Yeah, I wanted to just follow up with the point that Nick was making with regard to paragraph F. So I think it creates an issue even for urban counties. As the administrative judge here, people already think that I have some sort of power to be able to take my colleagues off of cases. This is, the public as well as other attorneys that don't like the way the judge is handling the case. And so they come to me thinking that I have some ability as administrative judge to pull that judge off and appoint someone else, or to pull that judge off, put their case back in the hopper so that it can get randomly assigned. I'm kind of concerned. Well, so first of all, I don't think the rule should indicate that the administrative judge is going to appoint someone, because I think that one is just going to set up another appellate issue if I appoint the wrong person. I think the better way, I think the judge that had the case should keep the case unless the person believes that that judge cannot be fair and impartial, and then they can file the appropriate affidavit of prejudice in the case, because obviously the judge that handled the case is going to have some additional knowledge that a new judge is not going to have, and is going to need to come up to speed to sort of appreciate the history of the case, as well as what happened during the original trial as well. So I didn't quite understand the purpose of F, and so I tend to agree with Nick. I mean, not only rural judges, but I think it creates additional issue if you're wanting the administrative judge to select someone, because that takes it completely out of random assignment. But I also think that it's better that the case does go back to the assigned judge, and then if the attorneys or the parties believe that that judge is somehow prejudiced, to file the appropriate motions, then to get it assigned to someone else.
Okay. Thank you. John?
Your Honor, Andy Wilson just sent a chat saying that he has to cut off in a minute for some other commitment. I would gladly yield to Andy if he would like to go first, if he had something
Andy,
he wanted to share with you.
I don't see.
I'm still on, thanks. I was actually typing, I hit return, and that jumped up on the chat screen before I got all my comments in. So I'll just go ahead and say I'm pretty quick. First of all, with subsection A, I'm a little concerned that changing that standard drops it too low. If somebody has been convicted beyond a reasonable doubt and they have new evidence of their innocence, I don't think it's too much to ask that evidence be clear and convincing. So I like the original language. And then I agree with Judge Savaggio and Judge McIntosh that that subsection F is problematic, and something that hasn't been discussed is the potential for forum shopping in smaller counties. Even I mean, it's a problem for the one judge counties like Judge Savaggio, but even in a county where you have 2 or 3 judges, I think it creates a problem. I agree with Judge McIntosh, the point that he just made, that maybe if you put may instead of shall in subsection F, then that allows for, if there is an actual claim of bias or prejudice, then the administrative judge could, or whoever's going to make that appointment, could consider it at that point. Those are my 2 points. And again, I apologize that I do have to jump off a little bit early.
That's all right. Thank you for joining us, Andy, and your comments and the participation. Appreciate that very much. John, back to you.
Thanks, Your Honor. You know, I want to go back to Judge Salvaggio's comment about we need to say what we mean. And I'm looking at and by the way, this is a wonderful draft. And I agree with its intent. And full transparency, I was part of the group of with OPD that was working on this in the last couple of weeks. But what I'm saying now kind of goes off of that draft. If I sat down tomorrow morning at the Bay Diner and somebody said to me, "What are you doing on this 33.1?" I would say, we're trying to find a way to say the following. The jury came back with a verdict of guilty. We've got this new evidence that could have been heard at trial. And if the jury had heard that evidence, they would not have returned a verdict of guilty. They would have come back not guilty on that charge. That's the kind of newly discovered evidence we're concerned about. That to me is kind of the essence of this. Now, am I saying for sure it would have happened? No, that's why reasonable likelihood is a good line, because you can't have absolute certainty. But to that end, and especially with the insertion this morning of that relevant and admissible evidence, which I think is just a great insertion by Justice Donnelly. With that, what if we got away from a couple of words here that worry me because they kind of can be misinterpreted as to what we mean by them? And those 2 words are material and contradicts. And what if we said something to the following effect? A new trial may be granted on motion of the defendant if the defendant produces relevant and admissible evidence not previously considered that, had it been considered by the trier of fact, produces a reasonable likelihood that a guilty verdict would not have been returned. Something to that effect. By getting rid of material, we get rid of kind of the squishy words a little bit, that undermines is a little bit of a word that one judge is going to say, well, yeah, you brought me evidence of the fact that the 5 eyewitnesses to this case, 4 of them have now said that they're all members of the same gang and that they all made up this story in order to convict this guy because he was a member of the rival gang. And they've also said that the 5th guy who testified was also part of the same gang and that he did the same thing. But the 5th guy says, no, I didn't. I saw it. I stand by my word. Some people would say, well, have you undermined it? They still have 1 eyewitness who hasn't changed his mind. 4 out of 5, I would say undermined. 2 out of 3, is that undermined? 1 out of 2, is that undermined? That kind of slippery slope, it creates some of what I think could be interpretive problems. But at the same time, by staying with Justice Donnelly's words about relevant and admissible evidence and staying with that line at the end about reasonable likelihood, but let's get away from saying different outcome, a different verdict. That's what we're saying, a not guilty verdict. So let's just say it and say something to the effect of what I've just suggested. What I'm trying to get at is, would that, and I'm asking the question because I support what's here, but I guess I'm asking the question, does that start to answer some of Judge Salvaggio's concerns about being, about plain speak, and some of our general concerns that we're raising about trying to define innocence, recognizing that it is not something that can be proven to a metaphysical certainty. Thank you.
Thank you, John. So Mark, you have your hand up, as does Doug. I don't know, is your hand up, Mark, addressing John's point? Yes, Mark?
Sort of broadly, several people's points.
Okay. I would like to just concentrate on John's suggestion about refining subparagraph A grounds. Doug, was your hand up as it relates?
I mean, I do think that it goes to that. I think that before we have that discussion, I would love to be able to throw these points in.
Okay, go ahead.
I just want to make sure that particularly people who have a problem with clear and convincing. I mean, the law as it stands now that the Innocence Project and OPD and these organizations have worked with is similar to what's right here. It doesn't have clear and convincing. The law we've been operating under is strong probability of a different outcome at trial. We changed that to reasonable likelihood because we've been able to show empirically that Ohio standard's higher than anybody else. Almost every other state has something like reasonable likelihood. And there's not a huge difference between strong probability and reasonable likelihood, but we changed it to get in line. And the whole point was we're not getting to the merits in our cases because the judges have created these different ways to throw cases out on timeliness issues and stuff. If you add clear and convincing in, we've come into a task force where we're trying to get rid of some of these procedural barriers so we can actually get to the merits. And what we've done is we've made the merits even harder. I mean, because when you see words like clear and convincing, it's hard to sort of quantify exactly where that falls, but most judges put that more toward beyond a reasonable doubt. And we're taking Ohio that's already an outlier by saying strong probability instead of reasonable likelihood. And now we're saying it's got to be clear and convincing evidence. And so I would be strongly opposed to that because it's starting a task force to try to improve things and it's taking it in the complete wrong direction. I'd rather leave it the way it is now. And I think part of the problem is that people are getting hung up that if somebody's successful in this, it means they're declared innocent. They're not. And I think anybody looks at it, if you had a family member or anybody that's like Angela Garcia, where they were convicted on something that we now know is junk, it's not discrediting the jury. It's not discrediting proof beyond a reasonable doubt. It's breathing life into those. It's saying these people, these jurors and this judge had this case 10, 15 years ago that we now know is basically monopoly money. They weren't given the right information. We're not declaring this person innocent. They get a new trial. And if the state can't convict them the second time around, that's how America works. Somebody who's been convicted on something we now recognize as junk, who sits around and goes, yeah, we think that person should spend the rest of their life in prison. They shouldn't, unless the state can convict them. So this is breathing life into due process. This is breathing life into proof beyond a reasonable doubt. This is breathing life into fairness. And so I think it's important to recognize, like, we are not declaring these people innocent. We're saying, we're recognizing that the jurors and the fact finders and the judges and the first time around, we're playing with monopoly money. They didn't have everything in front of them, and it needs to be redone. So again, I anything with clear and convincing, I mean, beyond the fact that the point I already made, you have then two incongruent standards. The standard has always been reasonable likelihood of a different outcome, and I'm fine to change it to reasonable likelihood of acquittal or reasonable likelihood of not guilty. But you know, clear and convincing is when you're talking about a fact that's either thumbs up or thumbs down, and clear and convincing evidence that this happened. Okay, you can't say clear and convincing evidence that you win by a preponderance. Those two standards sort of, or clear and convincing evidence that it's proof beyond a reasonable doubt, because the second part of that is something that's more wishy-washy, this totality of the circumstances, where you've got to weigh different types of evidence. And so clear and convincing could never go with the second half of that. It contradicts. But in any event, once we added that language in, we've gone in the wrong direction. We've made it harder than what's the current law is.
So Mark, you would accept or support John Martin's suggestion of the modification to a language? Is that right?
I mean, I would want to reserve the right to think more about it because this has just popped up, but off the top of my head, I mean, it's saying the same thing. I mean, a reasonable likelihood of acquittal, had it been considered a reasonable likelihood of acquittal.
With less words.
Yeah, and it's going more toward capturing the spirit of innocence.
Yeah.
I mean, because again, I think anybody would agree if you've got people that were convicted on evidence that we now know the jury would have come out different, why should that person why should they be in prison? That's not how this country works, right? Unless the state can convict them on real evidence.
Right. Thank you, Mark. Doug?
Thank you. I think John made some good points in terms of kind of how he defined the issue and scope in terms of the, kind of framing the issue around if we had newly discovered evidence, would it have come back differently? And I think that highlights a kind of a fundamental difference in how, at least maybe I'm misunderstanding the purpose of the task force, because I was not seeing this as is the purpose of this to examine convictions where we have reasons to think they might be there could be issues with them, or is it is the purpose of the task force to look at convictions where we think someone's actually innocent? And I think I thought he did a nice job of kind of delineating the two ways to frame it differently. And I think that I would prefer framing it the way that around actual innocence. So a way that it could be worded, I suppose, on the A would be a new trial may be granted on motion of the defendant if the defendant produces evidence not previously considered that demonstrates by what insert our burden here, clear and convincing, substantial likelihood, whatever, that the defendant did not commit the crime for which they were committed. It focuses the ball right on actual innocence rather than on undermining theories of guilt, and it doesn't require them to prove anything to a certainty. It requires it to prove to whatever burden we feel is appropriate to hold them to. And I think that's more of that's more in line with what my understanding of the original purpose of the task force was, is to look at folks who are actually innocent, not we might think fairness, however we want to define that, deserves another bite at the apple, another trial.
All right. Did you write that language down that you just, or did you just do that off the top of your head, Doug? Your rewording of A that you just said to us. Okay, I mean, I think that's a proposal language that is worth consideration, and rather than just people think about it and say, I think I can support that. I mean, we're getting down to having to make decisions of what this task force can support or not support, and I really would like to see that language. So I'm just, if you have it written down, you can have it sent to. Did you just put it in the chat, Doug?
I'm writing it in the chat now. I'm sorry.
Okay, that's all right. Great. That way, Brian, you can pull that up, and we have the various versions. Same question to you, John. Your language.
Yeah. Let's Mark Gotzi just made a good point in the chat that let's keep in mind that the task force is called conviction integrity, the integrity of the task force. And when someone is acquitted at trial, it doesn't mean that they're innocent. They're not found not guilty. There's plenty of guilty people over the 14 years
There you go. Thanks.
that I presided over trials at Common Pleas Court that I was convinced were actually guilty, but they were acquitted. So we're not trying to establish someone's innocence. We're trying to establish whether they deserve another trial, and the state has a full opportunity to go forward and prove their guilt, just not using where the defense is allowed to use this new evidence in their defense, or the state is not allowed to use evidence that is not scientifically reliable.
Okay. Meredith, you have your hand up, and then Judge McIntosh. Meredith?
Yeah, sorry about that. So to me, this seems more like, I know we're talking about the word undermined, but it's really, it's whether or not the fact finder had an ability to find the truth at the time. So it's almost like the same as a finding of a mistrial during the trial. And it's sort of like a post-trial, remand, because there would have been evidence that the fact finder would have had to consider in order to find the truth. So I just kind of wanted to respond to some of these comments about, whether or not we're opening up a can of worms. I don't think so. And I think this is exactly why we're here, to create a vehicle to, an avenue for people who should not have been convicted, who produce relevant material evidence, to have an opportunity to have a fact finder find the truth. So I don't know if you want that language in there, but just to recenter us, I think that's really I think that's kind of what we're trying to get at here. And I mean, that's about it.
All right, thank you. Judge McIntosh?
Yeah, thank you. And I just have a question, and then hopefully everybody can kind of help me make sure that I fully appreciate this. I thought the new 33.1 is being created to look at those fairly specific cases in which there are allegations of actual innocence, and everything else would fall under 33. Because well, for purely selfish reasons, I don't want to be having just a ton of hearings on persons that are challenging things that happen in the lower court that don't go to actual innocence, but just go to improper procedures that took place at the lower level, or things of that nature. So that's what I'm just trying to make sure that I understand and appreciate that 33.1 is supposed to be for a limited set of cases in which there are claims, at least, of actual innocence, and the evidence that has been brought forward is evidence that was not considered at the lower level. But then every other situation in which someone wishes a new trial would fall under 33.
Okay. It's anybody want to respond, Justice Donnelly or Mark, as it relates to?
Yeah, I totally agree with Judge McIntosh that that's what this is designed for. I think that we can fashion someplace in this rule where it's understood that that's what we're talking about. The Innocence Project doesn't pursue cases where they just believe that someone was unfairly convicted. They pursue people that are claiming that they're innocent, and same with OPD, wrongful conviction. We're trying to find a happy medium between the fact that in our system, people who are acquitted aren't declared innocent, and it's hard and we don't want trial court judges to misunderstand this rule that, well, they haven't convinced me that they're innocent. That's not what we're trying to convince the trial court judges. We're trying to convince the trial court judges that their original conviction lacks integrity for this, because of this new evidence, and they deserve a new trial. But everyone that is going to be pursuing this rule conceivably is claiming actual innocence, or or they would have been found not guilty had the original jury heard this new evidence we want to present, which significantly undermines the theory of guilt. Every case is nothing more than an accusation in which the state presents a theory of guilt. And if the defendant is convicted, the jury has bought the argument that they have proven the truth of that charge beyond a reasonable doubt. It's a theory. The prosecutor wasn't there. The defense lawyer wasn't there. And, if that theory is undermined because of this new evidence, a serious recantation, it should be examined at a hearing and decide whether it's credible and to what extent it undermines the case. And then the jury, let the trial court make the call on whether they believe a new trial is warranted. If they don't think so, then you have a record that can go to the Court of Appeals and they can review it and provide meaningful review. So I think just keeping the eye on the ball, that we're talking about a new trial in that respect, I think satisfies everybody's concerns.
I thank you, Justice Donnelly. There has been some chat entries. John, thank you for submitting yours. Doug, thank you. You submitted yours as well. And then Judge Savaggio has suggested a modification of John Martin's. And I don't know if I want to make sure everyone has seen that, because quite frankly, it's distilling down, I think, two related but separate proposed languages for subsection A that I think everyone needs to look at to see whether or not we can reach consensus or potential vote as it relates to subsection A. Okay. Any more discussion as it relates to subsection A at this time? We've had some good discussion. Mark, go ahead.
I just want to emphasize a couple points. It's very hard to get new evidence that you can bring back to court, which makes a fact finder go, that's powerful enough that this guy would have been acquitted. I've been doing this for 20 years. We've looked at thousands and thousands of cases and have gone forward to a court saying we think the standard's met, far less than 1% of them. And it's a hard standard to meet. And there's not many defendants, there's not many prisoners, there's not many inmates that actually have evidence you can look at and go, this is worthy of a debate. This actually might have changed the outcome. This person might have been acquitted, right? And that's why the vast majority, I'd say 99.8 or 9% of the cases the Innocence Project looks at, we ultimately don't move forward on. And then when we do, it's hard to even win or get a court to actually consider the fact that the outcome might have been different. And a lot of times we end up winning these on appeal. So this is by no means an easy standard, but I want to talk about actual innocence for a minute. There are people that I believe are actually innocent that we've litigated on this standard for and won and gotten them out of prison. I can't prove that they're innocent. And if you ask me early on during the investigation, I mean, I'm doing two things. I'm saying, can we develop the evidence? Is there evidence here that this was sort of a joke trial? And if the jury had gotten the truth, if they'd gotten the full story, they would have acquitted. I would call that the technical ground. We can win this case. But there's a second question we're asking ourselves. Do we think this person's actually innocent? And we've got cases where we've gone past the first threshold and I think we could win it. But there's reasons we think they're not actually innocent. A lot of times that's attorney-client privilege that I can't reveal. For completely other reasons, I'm not going to go forward on somebody unless I'm comfortable myself that they're innocent. But does that mean I'm right? No. I don't know what happened there. And I'm always going to be open to more information that comes forward. And we can never know. And this is one of the things that for doing this for 20 years, on the other side, law enforcement, the cops and prosecutors will say with absolute certainty they know this guy's guilty. And I'm not going to fall into that same trap because none of us can know that. Right. And so, you know, so how do we resolve this? We can't define this innocence. If you want to have something that says the defense attorney verifies that they believe there's a possibility that they, in good faith, they believe this guy's also innocent on top of that, well, that's not going to affect me. I'm not going to go forward on a case unless I meet that standard, even if I think I can win. I mean, I'd have to talk with OPD and other people. I think that's probably problematic ethically and for other reasons. But I mean, I'm probably the only one on this call that would be like, okay, I'm okay with that because I'm not going to do that anyway. I'm not going to bring a case unless it technically I can win it. And also I have a reasonable belief that they're innocent. But I don't know how, you know, I don't know how you can make that part of the rule with, I'm not sure. I'm asking for help there. And OPD and Joanna and Rachel and other people. I mean, that would satisfy the Ohio Innocence Project, but I think it leaves everybody else. I'm not sure that's the right standard.
Well, you may have stumbled on something there that the attorney believes in good faith that there's a high probability that the person is innocent. Would that satisfy the other side?
Think about that. Doug, you had your hand up.
Yeah, the one thing I was going to mention, Mark Godsey's point, I actually 100% agree with him in terms of the work that OPD and the Innocence Project do. They don't take 99 or 95% of the cases that walk through the door. I'm not concerned about necessarily the work and the avenue that they do here nearly as much. I'm concerned about that other 99 or 95% of the cases that trial judges are going to be reviewing that don't go through that channel of OPD or the Innocence Project, because on all of those, there is a perverse incentive that we're creating in here for people to put pressure on witnesses for years to come to recant, to continually challenge the finality of judgments and verdicts. And I don't think that we can view it all through the lens of the good work that OPD and the Innocence Project do on these, because there are a lot of other bad actors out there that form the bulk of what the motions that trial judges see all the time are. They're not the ones that Mark and Tim see on a regular basis. They're the more frivolous ones. And the mere fact that the court might not grant that at the trial level, that still doesn't change what the other bad actors in the system are doing to try to secure these recantations, to try to find experts who will say anything. And I think that that's a serious problem that we're baking into the system here by kind of some of the decisions we're making in terms of undermining guilt rather than actual innocence. Regarding the good faith belief, just point real quick that Mark brought up, and it was kind of mentioned in terms of, or Justice Donnelly, I should say, that does have some of it that that does help some concerns there, that if you can't go forward on it, but we all know that that's not necessarily going to be much of a high bar depending on the circumstances, and people do have a right to file things pro se. So I'm not sure that we can just give them, put a blanket that an attorney has to review this and vouch for his client. I think that might be an interesting legal bar to put in there that I'm not sure anyone would want.
All right, thank you. I do think the issues that have been discussed thus far point to two additional subsections that there hasn't been any discussion on. And I want to move the discussion forward so we can at least have that talk. And that pertains, quite frankly, to procedure. So it's 33(1)(c)(2). The court may appoint counsel for an indigent movement under this rule. That is a procedural potential, but it provides no, as you can see, the way it's framed, there's no timing issue, there's no standard, there's nothing. It just says a court may. It doesn't indicate or give direction to the trial court as to when appointed counsel would be appropriate for an indigent movement. It might be the area that if there was some consensus on the proposal mentioned by Mark and Justice Donnelly just now, might be amplified therein. Clarification. I suspect the trial judges of this group would want a little more clarification about when would that appointment be appropriate. So I'm not sure if there's any, if other people share a concern relative to that section or not. If so, I'd like to hear that now. If not, we'll move on to another point that of clarification, which takes us all the way back to what Judge Salvaggio raised at the very beginning of our meeting today.
So with regard to the appointment issue, my concern was really directed at qualifications. And, you know, I don't know that I take a particular position on it, but I am aware that the Public Defender's Office has given the judges very specific guidelines on what type of attorney should be appointed for what type of level of offense. And it seems to me that to charge appointed counsel, again, particularly in the rural areas that may not have as part of their practice to really do a deep dive into somebody's claims of innocence. I'm going to use, you know, that phrase, that, you know, we kind of go back to maybe some suggested language I had before, that these cases should be driven through the PD's case, the PD's office first, or maybe the Innocence Project or some agency, at least to give some verified help to that appointed counsel that may get the assignment. So I guess in a nutshell, what I'm saying is either we need to define what type of appointed counsel is eligible to get these kinds of cases. I mean, I think that would help the trial courts out. Or B, mandate that these cases grow out of a review process that the OPD or Innocence Project or some other agency that's been established to handle some of these cases. Because frankly, from a rural county standpoint, I don't know that I've got attorneys that will be able to do this on a even semi-annual basis.
Okay, I wish Tim was on the call to help answer this, but I don't think either of the proposals that you've just suggested in any way are undermined by the language contained in C2. The language contained in C2 just creates the notion that you as a trial court judge have that right to appoint counsel. It would be the respective trial court's decision in his or her circumstance, all right, which would recognize that you in a rural county, that might be the public defender's office, because that really is the only legitimate attorney who could be appointed to review such a case, okay?
But I don't want us to create a standard that we can't meet.
Well, that gets to why I wish Tim was here, because in terms of, and you're right, they have in the process of reorganizing how reimbursements are occurring relative to private attorneys who are doing public defender work in respective counties, they've set up standards of experience to say, if you have this much experience, you're qualified to handle this level of a case. There isn't any for this type of case presently, but that certainly is, that would be an internal mechanism within OPD's offices that would say, for these type of cases, you need this experience. And then that could create a potential pool of lawyers. And given the reality of our virtual world, it isn't necessarily limited to those that live within the constraints of Champaign County for you, or Franklin County for Judge McIntosh, or even Highland County for Judge Rocky Coss, but rather would be a list of those that could travel or could do the work, okay, because they're qualified under OPD standards for reimbursement for the work being done. So that's, I think, separate from the rule itself to accomplish. If OPD is willing, if given a direction that we're going to, as a community and as a state, recognize that appointing of counsel is an inherent right that could be vetted or should be vetted by the trial court. And if that trial court determines that this is a case that warrants the appointment of counsel to give the authority for that court to appoint counsel. So, and I don't know if that helps clarify it or not, but I you know, your points are well taken, but I think the solution goes beyond the parameters of the language in 33. And I think 33 is just trying to attempt to create affirmatively this notion that trial courts should have the ability to appoint counsel in those cases where you have an indigent movement, and it raises issues that would warrant the benefit of counsel to consider. So, and I think you eliminate then all of the potential ethical issues that public defender's office have if they have to review everything and make a determination whether it warrants counsel or not. You know, I'm sensitive to that, and I initially thought we could do that, but I think the other way is the more appropriate way. You just appoint counsel like you would in any other case. All right.
Gene, I have one comment. I just got on about 20 minutes ago or 25 minutes ago.
I saw that.
In terms, yeah, on the procedure for appointing under C2.
Yeah.
I would like to see that merged into 3 after the court's made an initial determination, because otherwise there could be the argument that has abuses.
Oh, you're frozen, Rocky.
Discretion.
Judge Koss, you're not coming through. You're choppy, so we can't hear what you're telling us. Michael, can you check?
Gene, I think what he was starting to suggest was like some sort of merger with the frivolous
subsection 3.
The frivolous standard, and I think that's something that I think would make sense, that if there's like a threshold determination that the petition is not patently frivolous, then it would warrant the appointment of counsel.
There you go. Rocky, I think you're back.
I'm back. Can you hear me now?
I can.
Okay.
Let's try it again, Rocky.
Yeah, what I was saying is that
all right, we're still not getting Rocky. Judge Koss, you're still frozen, unfortunately. I don't know what the issue is, but so in other words, Pierre, would be to the suggestion would be to actually procedurally, once the court has made the determination that the indigent movement's motion is not patently frivolous, then the court could consider the potential, or maybe even require the potential of appointing counsel, because then that gets it to a greater chance that you're actually going to have a hearing on the matter, right?
Correct.
Okay. Thoughts on that proposal? I always take silence as
I agree with it.
Just to move it real quick on that issue.
Yeah, Doug, go ahead.
I can post language into the chat in a second, but in the petition for post-conviction relief statute, there's language that could be modified, particularly easy to put the patently, the language from the proposal earlier today, because it has before granting a hearing, or it could be before appointing counsel, and I'll put it in there so that you guys can take a look at it and modify it accordingly. But it might be something that it requires the trial judges review the record, look at all the information, and do all of that. So
okay, yeah, that's good. I like that reference back to post conviction. Okay, thank you, Doug. All right, so any other discussion then relative to this point at this time? If not, evidence hearing. So Judge Savaggio, ever being the articulate wordsmith that he is, had a good point about what does the last sentence actually mean? What is the court's decision? Which decision is it? And as I reread that evidence you're hearing, I suspect the reality is it's either or both, Nick, in which case what we probably should do is delete the phrase after the hearing and just indicate the court shall. And I actually think we should impose, again, consistent with the language that's found in the post-conviction relief, the obligation for trial courts to issue finding of facts and conclusions of law, whatever it decides. Okay, such that there is a clearer record and explanation as to why the court made whatever decision it made. If it denied the matter up front because not warrant the hearing, the explanation of that is set forth through findings of fact and conclusions of law. If it proceeds to a hearing and then ultimately rules thereafter following the hearing, it still would have the specific finding of facts and conclusions of law that form the basis of why the court either granted or denied the particular motion. Okay, so I think we eliminate after the hearing and put in the court shall issue findings of fact and conclusions of law. And there is language that I would just take from the post-conviction statute where they have that standard in there and just place that in here, obligating trial courts to explain why it is you ruled the way you ruled. Does that satisfy your concern, Judge Salvaggio?
Anything that makes it clearer is fine. I'm a little concerned about inserting conclusions of law, a requirement for conclusions of law if something is patently frivolous, what types of conclusions of law might we have to state?
That nothing raised by the petition warrants or satisfies the grounds articulated on a 33.1 that would warrant proceeding to hearing, and the matter is dismissed summarily. That's your conclusion.
If the Court of Appeals is willing to accept that as a conclusion of law, then I'm fine with it.
I think you're in the 2nd district, right?
Yes, sir.
All right. I don't think I have to say anything more than that. Anyone else?
Judge, on that topic, have we decided whether or not this is a summary dismissal is going to count as a final appealable order, and whether or not we want to even have an appellate right from those types of situations? I mean, it's not a constitutional right, so I think some of it's open for discussion.
Is a denial a good question, Doug? So let's ask the question. Is it something that needs to firmly be stated in this rule? Is it stated? It's stated in 33, is it not?
No, my concern was if we're making another vehicle here, do we want to have the full panoply of appellate rights applied to 33.1 as well? So including right to appeal, ineffective assistance of appellate counsel, all of that type of thing.
Yeah, I'm just looking at.
Gene, I added in G the appellate provision that was in the early draft of 33.1, but I think that's certainly open for discussion. Okay. We can add further clarifications on that for sure.
Well, what does the group think? Mark, your hand is up.
Yeah, I mean, I think there needs to be a right to appeal, because we've had cases deemed frivolous that the person ends up winning in the Court of Appeals or federal court and exonerated. So you can run into occasionally trial judges that just don't want to deal with it. You sit there and you wonder, did they even read the briefs? I mean, that can happen sometimes. And so, we're talking about, we want to eliminate procedural traps. I think there needs to be a right to an appeal. I mean, and if it's frivolous, it's going to be easy to deal with. But somebody who's actually got meat needs to be able to put that in front of an appellate court.
Do you have an automatic right to appeal on a denial of a 33 motion for new trial?
Yeah, sort of like what G says right there.
Right. Well, that's the proposal for 33.1. I don't think that's in 33, is it? Pierre, did you take that from 33?
No, I took it from the draft of 33.1.
Yeah, that's what I thought. Okay. Anyone else? Joanna?
Yeah, I would agree that there absolutely needs to be a right of appeal from the denial of a hearing and certainly from the denial of the motion. We're kind of in the middle of the research right now, but we have interns looking at all of Ohio's known wrongful convictions. There's about 85 of them. And so far, I mean, there's a good amount that are losing at the trial stage without, or, in the trial court without a hearing. And like Mark said, getting relief on appeal or down the road. That's certainly been our experience. For example, the Sutton and Phillips case, lost multiple times in the trial court and then eventually won on appeal. So I think it's absolutely necessary to have appellate rights.
When you ultimately appealed to the 8th District in Sutton, I just want to understand procedurally, the trial court had denied your hearing, but also had denied the actual petition, correct? The motion?
So we initially filed a motion for leave to file a motion for new trial. That was denied without a hearing. That was reversed on appeal. We went down and had a hearing on the motion for leave, but because it hit the substance too, we essentially counted that as the hearing on the motion for new trial as well. So at that point, the trial court granted the motion for leave, but then subsequently denied the motion for new trial, which is what we appealed here.
Would you agree, Joanna, then that 33 doesn't affirmatively guarantee the right of appeal on a denial of a motion for new trial under 33? Is that right?
I don't know what the language of the current rule is. In practice, we seemingly have a right to appeal and certainly appeal in all of our cases.
Yeah.
And I think just looking at our cases, if it needs to be said, then I think we absolutely should say it.
Generally speaking, you do have a right to appeal the denial of new trial as a practical matter. They do that. The question is, if we start providing a right to counsel, do you have the right to effective assistance? Can you do essentially a Murnahan appeal on the denial here? And it starts opening up the, I don't want to say floodgates, but it widens the circle quickly.
Yeah, it creates additional avenues of appeal. Yeah, you are correct in that regard. Okay. So Justice Donnelly?
Yeah, my view is that it absolutely should have a right to appeal. It's an important check. The Supreme Court justices, we deal with a significant amount of pro se motions, jurisdictional motions that we dismiss after we review them, but we take each and every one seriously and look to see if they have merit. And recently we just granted a pro se equal protection jurisdictional, no lawyer, but well articulated by the prisoner, claim of innocence. And we thought it had merit, so we just voted it in. So if trial courts there's going to be some judges who are invested in the truth of what the outcome that took place in their courtroom and refuse to believe that some type of manifest injustice occurred, and they're going to summarily dismiss claims as patently frivolous, which may not be. So I think that that opportunity for review needs to be there.
Do you think subsection G then should be clarified to reference that the motion is the new trial motion? In other words, it's the actual procedural motion as opposed to some other, to clarify that is, in other words, it's the disposition of a motion for new trial under 33.1. However, that's disposed of. If the trial court determines it to be frivolous, patently frivolous, and denies it summarily without the benefit of counsel or hearing, or denies it after counsel but prior to hearing or after hearing, it's the denial of the motion for the new trial and the disposition of that, which is, I think, what you're articulating should have the right of appeal. Is that right?
Yes.
Okay. Do you think G says that? Or could it be?
Yeah, however it's disposed of, either as patently frivolous or granting a new trial or denying a new trial, should be subject to review.
Yeah, I'm just wanting to see whether or not subsection G language, which creates or clarifies the right of appeal, needs any further clarification as it's presently written. That's the point of my question. Anybody have any thought or concern or suggestion as it relates to that?
The only suggestion I would make is that maybe clarifying it to an order on the merits, somehow reflecting that it is on the merits of the actual claim, and so that we don't run into res judicata issues if people raise, if things are dismissed, frankly, for procedural grounds early on. We don't necessarily want that to be every one of those going through appeal if they can merely refile it with the things that they omitted.
Okay. Anyone else? All right, well, Brian, we'll look to, I'm not sure if we have language, but we'll think about that. Other issues as it relates to 33.1 then? John?
With a little bit of trepidation that I even bring this up, but I think one of the questions that comes up is when we talk about actual innocence, how do other offenses within the indictment that may have been the subject of a guilty verdict or the potential for a lesser included offense fit into the mix? And let me just give an example. Let's say I've got a client who's been convicted of aggravated murder for having purposely caused the death of someone, or let's make it simple murder, make it a murder B, and a felony murder. And we find an expert 5 years later who said, you know what, the medical stuff on this is completely bogus. There is no way that punch that your client threw caused the death. This person actually died of some other unrelated matter. And so now I come back in and I say, my client's not guilty. He's actually innocent of felony murder because he did not cause the death. And somebody says, yeah, but he's still guilty of misdemeanor assault. Now, I've got a client who's serving 15 to life when the most he could have had was 6 months. Shouldn't I be allowed to, I don't want to weigh the question. Should I be allowed to pursue this type of situation via 33.1, or because of the fact that there is some lesser included offense that could have been brought out of this case, does this mean that I'm back to 33 with all the procedural disadvantages or attendant thereto, or without the procedural advantages attendant to a 33.1? And then the corollary to that, let's say I can prove my client was completely not guilty or completely innocent of the aggravated murder and the assault, but he was also tagged for a weapon under disability for a gun he never used, but that was sitting in his pocket at the time. So he still would have been convicted in a separate count of this other count. If we're going to talk about things like acquittal, what do we mean? The reason I use the expression different verdict or something to that effect on the offense of conviction was to anticipate this. But, in a spirit of transparency, I want to make sure everybody understands that's the reason why I use that language. And I think that's something we have to discuss, or something that needs to be considered.
Okay. Anyone want to comment?
I'll jump in. I tend to actually agree with John Martin on the issue in terms of it creates problems. Obviously, if a misdemeanor conviction would be a bar to, like, the extreme type of example he says there. And I do think we need to have some sort of mechanism in place. But the other type of extreme we need to also have kind of be cognizant of, if they're convicted of premeditated murder, but they're also convicted of murder B, and it effectively would have no effect on their sentence. Those are the ones where it's like, do we really want to go through, give them a new trial when they were convicted of inferior offenses, lesser included offenses, or the evidence, let's say, of premeditation wasn't there, but causation and everything else is on square. They would still be serving a life sentence regardless. So how do we want to handle the realm of cases all the way between what John Martin's suggesting and the ones where it's not going to have a practical effective difference on the unnecessarily on the conviction, or will have very little. And so I think it's a problem, and I'm glad he brought it up, but it's definitely one where I don't think even people like myself who are somewhat critical of taking steps away from actual innocence, it's innocent of the offense you were convicted of. I think most people would be on the same page in terms of there. But then there becomes some subtlety in terms of when there are inferior offenses that are so closely tied with the ones that they are convicted with that it's not going to have much of a practical difference.
Well, isn't there a distinction if whether or not that inferior or the lesser charge was vetted by the court? I didn't understand, John, in your scenario whether or not it was actually the if you were just talking conceptually that the conduct clearly qualified as satisfied the elements of the misdemeanor offense, but wasn't before the court didn't charge on it, didn't, so it wasn't really part of the case. John?
Well, Your Honor, I think that, in the situation that I just posited, it might be that the court would never have given at the original trial a lesser included offense instruction on the M1 simple assault. But if at the original trial, the lawyers had this evidence, then it may very well have been that they would have argued the entire case to the jury on the idea of this is an M1 simple assault. It's a lesser included offense. So whether or not it was charged in some ways may have been the product of the absence of this newly discovered evidence. And so I don't know. You raise a good point in certain circumstances, but I mean, that's the other aspect of it.
Yeah, okay. Judge Savaggio, you have your hand up.
So I think John's question is a great one. And my initial thought is that we would go back to Rule 33 and look at some of the work that I think this is the OPD that defined the inclusion of the phrase new evidence material to a legal issue. Now, I have a little concern about the inclusion of evidence of juror bias because I think that's covered already in misconduct of the jury. But that aside, I believe that this situation that John speaks of, the lesser included offense, goes to a legal issue in the case versus 33.1, where we are again trying to discuss colorable claims of innocence. And I think when we talk about colorable claims of innocence, what we're really talking about is the some other person did it defense, as opposed, or I didn't, this wasn't me, this was somebody else. And I think that's why we're having so much difficulty wrestling with how to define 33.1, because 33.1 really talks about that individual that there was a miscarriage of justice because this person had nothing to do with the case. We're not talking about whether they were fairly convicted of a certain level of offense or a spectrum of offense. To me, that goes to Rule 33, and that's why I don't know necessarily, and believe me, I understand Mark's point, and I think he raises a good one, that we don't want to try to prove somebody's innocence, but I think it helps us to chip away at this concept of what we're really talking about are colorable claims of innocence, and we need to be more affirmative of that.
So, Judge Savaggio, how does a court consider lesser included or inferior charges that was never considered before? All you're ultimately getting here is a new trial, right? For which you may want to consider, if the case develops, you as the judge, lesser and or inferior charges. But if it's never raised initially, in conjunction with ruling on a 33.1 motion, I'm not sure how you can bring that in, how that becomes relevant.
Well, but in one of John's examples, the assault versus the homicide.
Yeah, felony murder.
There's no question as to responsibility for the offense.
So I mean, your position would be, well, that's not a 33.1 petition, that's a 33 motion.
Right, because 33.1 is really dealing with the identity of the assailant.
I actually think this issue is relevant on merger cases. Because as you know, when you have two offenses that merge, you have either a plea or conviction on multiple offenses, but because of the doctrine of merger, only one of them is being sentenced.
Well, and
the right of appeal has to be for both. I don't mean to interrupt, but as you know, the right of appeal has to be for both.
Yeah.
Otherwise, you waive that.
But maybe the way to maybe further cut into 33.1, and I'd be interested to hear what Mark and Justice Donnelly would think, is aren't we for 33.1, aren't we really talking about where the identity of the offender is at question? I mean, is that a different way of saying where we're talking about actual innocence, that we're talking about the identity of the offender? And is that a better way of trying to herd cases into 33.1? I don't know. I throw that out.
Well, let's ask Justice Donnelly and then Mark and then Doug, okay?
Okay. So my take on it, I like that colorable claim of innocence, but I also want to clarify that actual innocence doesn't just mean someone else did it. It could just mean I did not do it. Let's take Angela Garcia for example. That fire could have been caused completely accidentally. It doesn't mean, and that no crime was committed. So it encompasses other people that it doesn't, it's not a concession that a crime was committed, but it does mean I did not do this. And I think the hypotheticals that John brought up, like I did the act, but I was really guilty of a lesser included. These are all issues that can be addressed on the defendant's direct appeal, and that's where those should be funneled through. And this rule should be for colorable claims of actual innocence. Where the integrity of the conviction can be demonstrated, no longer exists.
All right, thanks, Mark.
Yeah, I was paying attention to the discussion, but this is just answering Judge Salvaggio's. If it's a case where you're like, well, he's innocent of murder, but it should have been manslaughter, I'm not getting involved in that case. I mean, that person was there, they had a gun there. I mean, so, I mean, it's sort of going to the same point, like just me personally, to me, that's a sentencing issue. Were they convicted of the wrong degree? Were they convicted of the wrong role? I'm not going to bring a case like that. But again, it just brings us back to the whole problem of, I've tried to articulate after doing this for 20 years, I can never determine when someone's innocent. And I don't know how to put this into a standard. This is the only way I know. I'd love to have the ability to sort of confer with other people, because I don't want to be speaking out of turn, having not thought things through. But I mean, maybe, I'm talking about Joanna and John and some of the people, but like, I don't know if something can be worded that a colorable claim of actual innocence, where you're not requiring them to prove their innocence, but at least that there's a possibility before this provision's triggered. I haven't been able to think these things through, but I understand what everybody's saying, but I also deeply believe you can't define this. So it's sort of a catch-22.
Thank you, Mark. Doug, I think you had your hand up, and then John.
No, the only thing I was going to say is to echo Judge Salvaggio's point. I do think that if we wanted to try to stay away from the word actual innocence, but by by defining it essentially out of existence, other than the person didn't do the crime. You could do a no criminal offense was committed, or the offense for which the person was convicted was in fact committed by another person. I think that goes to some of the issues that Judge Chavaglio as well as Judge Donnelly were raising in terms of kind of looking at the world of actual innocence claims, because I don't know that we want the perfect to be the enemy of the good. If you make the funnel wide enough, you're going to sweep in way too many claims. But do we want to, knowing we might miss, one or two over the next few decades, is it better to create a good funnel rather than the perfect funnel to prevent being over-inclusive and swamping trial judges?
Thank you. John, you had your hand up. Did you want to?
Very quickly?
Yep, good.
The scenario that I was positing would not be able to be addressed on a direct appeal, because the evidence to show that it was the simple assault and not the murder didn't come to light for 5 years or something like that. And I think that there has to be, we want to make sure that we don't have somebody sitting in prison for the rest of their life on what should have been a simple assault simply because their attorneys couldn't meet the procedural requirements of 33. That would be the one thing. And that's where 33.1 has an advantage. As far as trying to define actual innocence, to go back to Mark's point about you can't define that, and in some ways it's proving a negative, is I think that the idea that the jury came back guilty, if they had known this, they'd have come back not guilty. That to me is actual innocence. And if we word it along the lines of that jury verdict, that toggle, that is probably the best we can do, and probably is the best we should do, consistent with the presumption of innocence. Okay,
so it is 11:57. So here's what I suggest we're going to do. As I've listened, and we've had great discussion today, and I thank you all for your diligence and suggestions and input. It strikes me that of the proposed language of 33.1, there really isn't, I think there's a consensus about the concerns relative to subsection F that would warrant its complete elimination from what we're going to do next. And unless I hear any real opposition, we're just going to delete this notion about the administrative judge removing in a version of 33.1 that I anticipate submitting to you so that we can vote on it going forward, okay? You will note on our agenda that we are scheduled to meet on May 7th. That May 7th date is less than a month away, and actually is sort of a placeholder that I put in there anticipating this very outcome. So what I am suggesting we will do is, and I thank you for your suggested language, we are going to type up the proposed language, and there's competing languages as it relates to grounds and subsection A, and we will rework the language, merging. I don't think there's any, I think everyone agreed that subsection C2, appointing a counsel, should be merged with 3 and only occur after a determination that the motion is not patently frivolous. And we'll work on modifying that. But we will submit the language that we have received from you all today that's in competition with you, Audra, as it relates to 33.1. And then we're going to meet on May 7th at 10 o'clock, and we're going to vote out and see if we can reach a majority and hopefully a complete consensus as it relates to language for 33.1 using all of that input. All right, that's what I intend to do. I have to remind everyone that the chief, while patient, is indicating that we do need to move forward in making recommendations, whatever they may be, and I'm charged with trying to frame that, which is how which is why I propose what I've just done. I would also indicate that, Joanna, you guys sent us this morning, or sent me this morning, your proposals regarding 29, 53.21 and 2.3. And I thank you for those. I'm going to ask you, however, if you have I can share this with everyone, I presume, correct? Joanna?
Yes.
Okay. But in addition to that, if you're looking to modify the actual language of the statutes, I would ask that you provide those specific statutory modifications sooner rather than later, so that we can share them with the task force and have the type of meaningful discussion that we've had today about specific language, so that we can move forward on voting on that as well. I will tell you that Brian Schmenk and I worked on, and I was going to submit today, and I think we'll send it out, Brian, proposed language modifying 2953.23 that puts in time constraints on the trial court, requiring them to rule on post-conviction petitions within a specific prescribed period of time. And you'll see that. If any of you have alternative language of changes to the post-conviction statute, I would also ask that you submit them to us so we can share them with everyone. Otherwise, and then what we'll do is on May 7th, after we complete voting on the proposed languages of 33.1, we'll then transition and have a full discussion as it relates to post-conviction. And I would ask Joanna, I mean, these are expansive and really interesting suggestions that you have raised, and I appreciate receiving them. So I'm going to be looking to you and Tim to present your concepts at that time. Okay?
Yes.
Excellent. Questions, comments, anyone, before we adjourn at noon or 12:02 now?
I just say one real quick thing is I agree, Judge Zamuda, that I don't think F should be a deal breaker for this rule. I think Judge Salvaggio and Judge McIntosh articulated some very valid concerns, but I also understand the concerns to why it's being proposed, and I have some other ideas how we can address those concerns that I will discuss with ODP and Innocence Project, but I don't think it should sabotage what we're going for.
Yeah, there are other avenues in other rules outside of 33 or 33.1 that those issues that I think subsection F is attempting to address allows. And it might not be as clean as that, but there is an avenue to address some of the concerns that I think is precipitated the proposed language there. So, anyone else? If not, thank you all very much for your engagement and participation. We will all see you on May 7th at 10 a.m. Have a good weekend, everybody. Brian, can you stay on? And Catherine?
I don't know if we can do that with it being a YouTube link, but I would be happy to circulate with you and Catherine a separate Zoom link out of my account, so we make sure we don't have any overlapping issues with that.
Yeah, what do you say, Michael? Is that the cleaner way of doing it?
That's fine. I could end the stream. I was just gonna say, and I'll end it right now. The YouTube stream's ended, but if it's easier for you guys, yeah, if he just wants to send you